Hello, my name is John P.L.C. Today is Wednesday, April 13th, 2016, and I'm going to be speaking to you today about Florida's offer of judgment statute, sometimes referred to as the proposal for settlement statute under Florida law. It's a fee-shifting statute, 768.79. 768.79, Florida's offer of judgment statute or proposal for settlement statute. A very important appellate decision just came out today out of the 4th District Court of Appeal, which addresses the issue of whether the proposal for settlement statute may be used in an action where not only monetary damages are sought, but also equitable relief is sought. The Florida Supreme Court did not answer that question definitively, but at least in the 4th District, that question now has been answered in the affirmative, when the true relief that the plaintiff is seeking in the underlying action is monetary in nature and not equitable or injunctive in nature. So let's get into this. This is an April 13th, 2016, 4th DCA, 4th District Court of Appeal appellate opinion. It's a consolidated appeal. It's MYD Marine Distributor Incorporated, M as in Mary, Y as in yellow, D as in dog, versus International Paint Limited, and there's other plaintiffs and defendants involved as well. This was released earlier today, and it involved a final summary judgment that had been granted in favor of the defendant, who was alleged to have committed conspiracy regarding price fixing, conspiracy and restraint of trade, and breach of contract. The plaintiffs lost, the defendants prevailed at final summary judgment, and so the defendants then moved for attorney's fees and costs. The costs judgment was affirmed without comment. The issue before us is one of attorney's fees under that fee-shifting statute, 768.79. So the appellees were the defendants who received an award of attorney's fees. The unsuccessful plaintiffs appealed that. They're the appellants, and they went to the 4th DCA, arguing, among other things, that the award of attorney's fees at the trial level was improper. The offer of judgment, the proposal for settlement, was improper and invalid because in the plaintiff's case, they asked for monetary damages as well as equitable damages or equitable relief in the form of an injunction, an injunctive relief, a permanent injunction of relief regarding permanent injunction enjoining the defendants from continuing to supposedly engage in this conspiracy. The plaintiff failed, the defendants won. Okay, so let's get back to the issue of attorney's fees in a civil lawsuit in Florida when monetary damages are sought as well as injunctive relief. We know that generally speaking, Florida's offer of judgment statute or proposal for settlement, 768.79 Florida statutes, is limited to an instance when there are many damages. In 2013, the Florida Supreme Court in Diamond Aircraft Industries versus Horowitz stated that the courts then were uncertain whether the proposal for settlement or offer of judgment statute, 768.79, could be used when monetary damages are sought in addition to injunctive relief. So previously, many appellate courts in Florida said if you're seeking injunctive relief or equitable relief in addition to money damages, the offer of judgment statute does not apply. Why? Because the offer of judgment statute, the proposal for settlement statute, only applies to money damages. And the Florida Supreme Court in Diamond Aircraft said, maybe, maybe not. They said it's less clear. They said that Florida courts have not decided whether a party may utilize section 768.79 when he or she has asserted separate claims for monetary and non-monetary relief in the same pleading, and the opposing party has served an offer directed specifically to the monetary claim. And that's what happened in this case from the 4th DCA. The defendant made an offer of judgment or a proposal of settlement to the plaintiff prior to the order on the final summary judgment, or the summary final judgment, saying, hey, we want to resolve all your monetary claims with you, and we specifically don't want to settle the non-monetary claims, right? They read Diamond Aircraft very closely, and they carved out an offer of judgment or a proposal for settlement specifically related to the monetary claims, and specifically excluded the non-monetary claims. The trial court agreed, and they said, we're going to award fees in favor of the defendants and against the plaintiffs. The plaintiff said, no, you can't do that. I brought equitable claims or non-monetary claims, as well as a claim for monetary damages. The offer of judgment statute, Florida statute, section 768.79 is inapplicable. The fourth DCA disagreed. And they said, reading Diamond Aircraft, is that you can use the offer of judgment statute or the proposal for settlement statute when the true relief which is sought is actually monetary in nature, and when the damages are not non-monetary in nature. And so you definitely want to read Diamond Aircraft. The site for that is 107 Southern 3rd, 362. It's from 2013, Florida's Supreme Court. And you also want to read this fourth DCA case that was handed down today, April 13th, 2016. It consolidated appeal. I'll give you the first one, 4D, 4th District, 4D 13, filed in 2013-2496. 4D is in District, 13-2496. So you're probably wondering, why is John P.L.C, a probate litigator in Florida, speaking to you about a non-probate statute or a law that has to do with attorney's fees in a non-estate setting, a non-trust setting? Certainly we know that in the Florida probate litigation world and trust litigation and guardianship litigation, there are statutes. There are fee-shifting statutes in our Florida probate code, the trust code, and the guardianship code that permits people who are involved in Florida probate litigation to obtain fees and costs. Okay, why are we concerned about a civil action regarding conspiracy and price fixing? For two reasons. One, in the estate lawsuit context, you can declare a proceeding to be adversary in which the rules of civil procedure will apply. In addition to that, increasingly one of the growing trends in the probate litigation world in Palm Beach County, throughout Florida, and throughout the country, is you're seeing plaintiffs or petitioners embracing more typical or traditional civil causes of action rather than traditional equitable actions or non-monetary damage actions that have traditionally been in the probate world. So you're seeing, for example, people who have been disinherited under a will or an estate plan in Florida file a tortious interference with an expectancy lawsuit, sometimes called a tortious interference with an inheritance lawsuit. You do see conspiracy charges brought, torts for conversion, torts for civil theft. Remember, in Florida at least, if you have an estate lawsuit or a trust lawsuit, you can get a jury trial on the tort counts, fraud, undue influence. You generally don't get a jury trial on equitable counts, non-tort counts. And certainly when you're asking for rescission or you're asking for the construction or asking a court to construe a document or to interpret an ambiguity, you're not going to get a jury. You're going to get a bench trial on that. So, MYD Marine Distributor Incorporated versus International Paint Limited, released today, April 13th, 2016. If you're involved in civil litigation in Florida, if you're involved in probate or estate and trust litigation in Florida, and attorney's fees, which I call or refer to as the X factor, are always an important factor because it's so expensive to try these cases. If you're involved with them, definitely read this case. It's available on the 4th DCA website by going to opinions and then scrolling down to today's date. Thank you.